The Chamber found that the motive underlying these legal instruments, as well as their overall effect, was to provide the property left behind by Croatian Serbs in the liberated areas to Croats, and thereby deprive these Serbs of the use of their housing and property. The Chamber found that this imposition of restrictive and discriminatory measures with regard to housing and property, considered in conjunction with deportation and other crimes against Croatian Serbs, constituted persecution. In conclusion, the Chamber found that Croatian military forces and the special police committed acts of murder, cruel treatment, inhumane acts, destruction, plunder, persecution, and deportation as charged in the indictment. Considering the large number of crimes committed against the Serb population of the Krajina region in a relatively short period of time, the Chamber further found that there was a widespread and systematic attack directed against the Serb civilian population. As mentioned, the prosecution alleged that the three accused were participants in a joint criminal enterprise. The objective of this alleged joint criminal enterprise was the permanent removal of the Serb population from the Krajina region. In assessing whether there was a joint criminal enterprise, the Chamber carefully considered the discussions at the Brioni meeting of the 31st of July 1995, a few days before the launching of Operation Storm. At this meeting, President Judgement met with high-ranking military officials to discuss the military operation. The Chamber found that the participants at this meeting also discussed the importance of the Krajina Serbs leaving as a result and part of the imminent attack. Responding to a statement by President Tudjman to this effect, Mr. Gotovina stated, and I quote, "A large number of civilians are already evacuating Knin and heading towards Banja Luka and Belgrade. That means that if we continue this pressure, probably for some time to come, there won't be so many civilians, just those who have to stay, who have no possibility of leaving." End of quote. The Chamber carefully reviewed the statements of high-ranking Croatian officials at this and other meetings and in public. The Chamber considered these statements in the context of its findings on the deportation, unlawful attacks on civilians and civilian objects, and the imposition of discriminatory measures, all of which were directed against Croatian Serbs. The Chamber found that certain members of the Croatian political and military leadership shared the common objective of the permanent removal of the Serb civilian population from the Krajina by force or threat of force, which amounted to and involved deportation, forcible transfer, and persecution through the imposition of restrictive and discriminatory measures, unlawful attacks against civilians and civilian objects, deportation, and forcible transfer. The joint criminal enterprise came into existence no later than the end of July 1995 and continued throughout the indictment period. The Chamber further found that the common objective did not amount to or involve the commission of the crimes of persecution through disappearances, wanton destruction, plunder, murder, inhumane acts, cruel treatment, and unlawful detentions or destruction, plunder, murder, inhumane acts, and cruel treatment. The Chamber found that Franjo Tuđman, who was the main political and military leader in Croatia before, during, and after the indictment period, was a key member of the joint criminal enterprise. Tuđman intended to repopulate the Krajina with Croats and ensured that his ideas in this respect were transformed into policy and action through his powerful position as President and Supreme Commander of the Armed Forces. The Chamber further found that other members of the joint criminal enterprise included Gojko Šušak, who was the Minister of Defense and a close associate of Tuđman's, and Zvonimir Čermak, the Chief of the Croatian Army main staff. The members of the joint criminal enterprise also included others in the Croatian political and military leadership who participated in presidential meetings and were close associates of Tuđman's. At the Brioni meeting, Tuđman and high-ranking military officials discussed how the military forces should be used to ensure that not only the Serb Krajina army, but also the Serb civilian population would leave the Krajina. The Chamber found that high-ranking Croatian military officials, including Tuđman, Šušak, and Čermak, used the Croatian military forces and the special police to commit the crimes within the objective of the joint criminal enterprise. The Croatian military forces included the Croatian army and military police, as well as Bosnian Croatian army units, which had been subordinated to Croatian army commanders. The Chamber did not find that the police forces, with the exception of the special police, were used by members of the joint criminal enterprise to commit crimes. The Chamber will now address whether criminal responsibility for the crimes of persecution, deportation, destruction, plunder, murder, inhumane acts, and cruel treatment is to be attributed to the accused. The Chamber found that Ante Gotovina held the rank of Colonel General in the Croatian Army and was the commander of the split military district during the indictment period. By virtue of his disposition, Mr. Gotovina commanded all units of the split military district, as well as those attached to it. Units of the military police in the split military district were subordinated to Mr. Gotovina in relation to regular military police tasks. The Chamber further found that crime prevention and crime processing were not excluded from Mr. Gotovina's authority over the military police. The Chamber found that the shelling of Benkovac, Knin and Obrovac on the 4th and 5th of August 1995, which were ordered by Mr. Gotovina, constituted unlawful attacks on civilians and civilian objects. The unlawful attacks formed an important element in the execution of the joint criminal enterprise. The Chamber further found that Mr. Gotovina participated in the Brioni meeting and contributed to the planning and preparation of Operation Storm. Moreover, Mr. Gotovina failed to make a serious effort to prevent and follow up on crimes reported to have been committed by his subordinates against Croatian Serbs. Mr. Gotovina's failures had an impact on the general attitude towards crimes in the split military district. Based on these considerations, the Chamber found that Mr. Gotovina's conduct amounted to a significant contribution to the joint criminal enterprise. The Chamber further found that Mr. Gotovina's orders to unlawfully attack civilians and civilian objects amounted in and of itself to a significant contribution to the joint criminal enterprise. Based on Mr. Gotovina's acts and conduct, including his participation in and statements at the Brioni meeting, the Chamber found that he had the state of mind that the crimes forming part of the objective should be carried out. The Chamber therefore established that Mr. Gotovina was a member of the joint criminal enterprise and thus intended that his actions contribute to this enterprise. The Chamber further found that other charged crimes, although not part of the common purpose, were natural and foreseeable consequences of the execution of the joint criminal enterprise and foreseeable also to Mr. Gotovina. The Chamber now turns to Ivan Čermak. The Chamber found that the formal appointment and title of Mr. Čermak was Commander of the Knin Garrison, but that his responsibility went beyond those of a garrison commander. The evidence established that Mr. Čermak had some influence over the civilian and military police, but not that he was in charge of and had legal authority for maintaining law and order. Mr. Čermak did not have effective control of over Croatian army units outside of his own subordinates at the garrison, and the Chamber found no reliable evidence that those subordinates committed any crimes. The Chamber found that the activities of Mr. Čermak included dealing with members of the international community, cleaning up Knin, improving hygienic conditions, providing a public soup kitchen, making the hospital operational, reconnecting water and electricity to the town, reactivating public services, improving transportation conditions, restoring factories and other businesses, and demining Knin and its surroundings. The evidence did not establish that Mr. Čermak knew or intended that his activities contribute to any goal of populating the Krajina with Croats rather than Serbs. As for Mr. Čermak's conduct with regard to crimes committed on the ground, the Chamber found that he denied and concealed the crimes committed in Grubori on the 25th of August 1995. It further found that Mr. Čermak, in general, provided misleading assurances to the international community that action to stop the crimes against Serbs were being or would be taken. However, apart from this, the Chamber found that the prosecution did not prove its allegations that Mr. Čermak permitted, minimized, denied or concealed crimes against Serbs, nor that he provided false, incomplete or misleading information or false assurances to the international community. The Chamber concluded that the evidence did not establish that Mr. Čermak was a member of the Joint Criminal Enterprise or made any intentional and significant contribution to it. The Chamber also found that Mr. Čermak was not liable under any other mode of liability charged against him. Finally, the Chamber turns to Mladen Markač. The Chamber found that during the indictment period, Mr. Markač held the position of Assistant Minister of Interior in charge of Special Police matters. While the Special Police was normally part of the Croatian Ministry of Interior, during Operation Storm and the following search operations, approximately 2,200 special policemen, including members of the Lučko anti-terrorist unit, were subordinated to the Croatian Army main staff and took part in the military operations. By virtue of his position, Mr. Markač had overall control over the special police forces, and throughout Operation Storm and the following search operations, he commanded them in accordance with the orders of the Chief of the Main Staff. Mr. Markač also commanded part of the artillery assets of the Croatian Army Artillery Group TS5, which were attached to the Special Police on the 3rd of August 1995 for operational purposes. The Chamber found that Mr. Markač participated in the Brioni meeting, contributing to the planning and preparation of Operation Storm. It also found that he ordered the Special Police shelling of Markač on the 4th and 5th of August 1995, which constituted an unlawful attack on civilians and civilian objects and brought about the forcible displacement of persons. The order to shell Markač amounted, in and of itself, to a significant contribution to the joint criminal enterprise. The Chamber also found, Judge Keane is dissenting, that Special Police members took part in the destruction of a substantial part of Markač on the 5th and 6th of August. The Chamber found that they also participated in the destruction and looting of Krajina Serb property in Donji Lapac on the 7th and 8th of August 1995. The Chamber found that Mr. Markač knew about the involvement of his subordinates in the commission of these crimes, but that he did not take any steps to identify the perpetrators in order to take appropriate action against them, nor did he take any step to prevent the commission of further crimes. On the 25th of August 1995, members of the Special Police murdered several elderly villages in the hamlet of Grobori. On that and the following day, the same unit also burned property in Grobori and Ramljana village.